Mergers and acquisitions significantly impact the South African business landscape, significantly influencing market competition and, of course, consumer welfare. Lebohang Mabidikane, who's the Director of Competition Law at Cliff Decker Hofmeyr, joins us this evening to discuss the implications of mergers and acquisitions. A very good evening to you, Lebohang, and thank you very much for your time. Now, as an expert in competition law, how does the Competition Commission balance the need for competition with the potential economic benefits of M&As?
Yeah, so in terms of the Competition Act, the Commission must first look at the impact of a merger on competition. And if it makes a finding that that merger would have an adverse impact on competition, then the Act provides that the Commission must consider whether there are any technological efficiency or other pro-competitive gains which would potentially outweigh the adverse impact on competition that that merger would actually result in. What that means practically is that the Commission would look at whether, for example, the merger would bring about innovation in a market that would not have been there if the merger had not taken place. Now, if you think about innovation, it's a very broad concept. You could be looking at the introduction of new product categories, for example. And, you can imagine the introduction of new products can potentially mean that there's an introduction of new jobs because a firm can potentially need more employees to create those products and therefore, stimulate employment as well as indirectly then stimulating the economy, because when more people work, then the assumption is that there's more money in a consumer's pocket to spend.
It's interesting because one wonders then how the Commission then defines market concentration within those realms that you've just spoken about and what the impact that would then have on the economy.
So, the concept of market concentration is really rooted in economic theory. But to put it simply, when we talk about market concentration, we're talking about a market where there's few players offering the same product. So it's got minimal competition because it's either an oligopolistic market where there's two or three even players, or a monopoly market where there's only one player. Now, the impact that the Commission perceives that concentration would have on the economy is that typically large players would engage in anti-competitive conduct, which would make it difficult for smaller players to then enter the market. What that then means is that you have a particular segment of the market that is kept out of economic activity because of the anti-competitive behavior of the large, potentially large players in that market that happen to be also very few.
Are you able to give us some examples of conditions where the Competition Commission imposed on mergers to maintain a healthy form of competition in, I suppose, a difficult operating environment in South Africa?
Yeah, so one of the examples I can think of is where a merger involves competitors who produce an important input into another competitor's product. Now, the theory that the Commission would be concerned with is whether post-transaction, then the merged entity would then stop supplying that important input to their competitors. And when the Commission identifies a theory of this nature, then the Commission would typically approve a transaction on condition that the merged entity continue to supply that product or that input to their own competitors in a manner which would ensure that that other competitor is able to continue competing with the merged entity post-transaction.
And then there's also that issue of public interest that comes into play, and I wonder if that includes the issues of jobs and really just what the operating landscape would look like should a transaction be concluded. So what are the main challenges that the Commission would face when looking at issues around public interest?
Yeah, that's correct. Employment is one of the public interest factors that the Commission must look at when assessing a merger in terms of the Competition Act. And one of the challenges that the Commission would have is really striking the right balance between approving a merger, which would be good for competition and thereby good for the economy, and ensuring that if there's any negative impact as a result of that transaction on employment, that that impact would be mitigated. A very good example of this is where maybe the target entity is experiencing financial difficulties. Now, typically when companies are in financial distress, there's really few options. One is either to merge with a willing buyer or to potentially liquidate, right? So in the counterfactual, where a target firm which is having financial difficulties would want to liquidate, then what that means is that all jobs would be lost. But if they find a willing buyer and they have a merger which is then assessed by the competition authorities, then the competition authorities would actually have to strike a balance between ensuring that that target firm which was experiencing financial difficulties is not only saved, but then some jobs as well are saved. So, this may also have really uncomfortable results for labor, for example, where labor is saying no job losses at all, but the counterfactual is really that if the commission does not approve that transaction and make sure the acquirer is able to improve that business and save some of those jobs, then the worst case scenario would happen, which would be that the entire job force would be lost, as well as the assets of that target firm.
Thank you very much for those very interesting insights, Lebohang. That is Lebohang Mabidikane, who is Director of Competition Law at Cliff Decker Hofmeyer, joining us this evening. With that, here's a look